believe we've lost Miss Lapp. One moment.
I've noticed.
Okay.
All right, thank you. We're here now on the last matter scheduled for hearing this morning, which is State of Ohio versus Randy L. Smith, cases number 210169, 70, 71, 72, and 73. If attorneys can please identify themselves and their readiness to proceed, beginning with Attorney Cohen.
Morning, Your Honor. Greg Cohen on behalf of Ms. Smith. Ready to proceed.
Thank you. Attorney
Judy
Lapp.
Lapp. You ready for the state? We have 4 of the cases are county cases. The city has asked if I proceed and then reserve 5 minutes for them to also argue.
Okay, so you will have 10 and they will have 5?
If that's still what they are comfortable with.
Okay. And attorney Vogt?
Morning, Your Honor. John Vogt on behalf of the City of Cincinnati. Ms. Lapp's correct. I request respectfully 5 minutes for my portion of the appellee's argument.
Understood. Okay. Attorney Cohen, would you like to reserve time?
I'd like to reserve 3 minutes, Your Honor.
All right, you can begin whenever you're ready.
All right, may it please the court, counsel for the opposition. Basically, this is an abuse of discretion argument, the weakest of all that comes before any reviewing court. I would point out, though, that both the city and the county have filed briefs in this matter. I've done enough post-conviction to know that if you don't argue something in the trial court, you essentially waive that issue. So I'm not sure what their interest is here because the record reflects that neither the city nor the county objected. But then moving on, there are several factors a court should use. Obviously, the most important, and I think what applies here is what is the legitimate needs of the government to maintain the records? And I'll go back to my prior argument that they waived that argument by not really stating anything at that hearing. They were
And doesn't the
fine.
statute actually recognize that there are times where there are no legitimate interest of the government?
I would agree. That does occur on occasion, but
Well, the statute says, if any, it's a weighing. One of the factors is the weighing of the interest of the applicant of having the record sealed versus the interest of the government, if any.
well, if the court said basically, she'd not established or put forth any or sufficient rehabilitation. Now, I'm not sure what that means because, again, there's no verbiage from the court that backs that up. You are eligible 1 year after a misdemeanor conviction has been finished, either by probation, fulfilling the sentence. And although I would argue that it's persuasive, it's not controlling, but, case out of the 10th said, evidence of rehabilitation normally consists of admission of guilt, promise to not commit similar offenses in the future, good character, and citizenship following the conviction. This woman comes forward with a horrible past, which was put before the court. Foster care, physical and sexual abuse, drug addiction. And she stood before the court 5 years after her last conviction for resisting arrest with her own home, paying a mortgage, her own business, paying the bills, and young children that she was raising. I'm not sure how you get more conclusive rehabilitation than somebody who has actually actively left the criminal world behind and begins the process, in this case, actually in the process of becoming a great citizen of this community, working, paying taxes, raising her family, paying her property taxes, essentially as a good citizen.
Now, the
Go
court
on.
seemed to find significant that one of the cases was a little bit more recent compared to the others. And it appeared as if the court was considering that in determining rehabilitation. How would you address that?
One can only guess. The court really gave us nothing to go with. City and the county argue, obviously, a loaded firearm in a motor vehicle is serious. I'd point out the court was advised that her felony was expunged prior to that hearing. The case that is referenced with the handling of firearms from 2005. The 2016 case was when she was still suffering from drug addiction. There was a paraphernalia charge and illegal drug instruments charge that were dismissed when she pled to the resisting arrest. She tried to run from the police, fell flat on her face, and wouldn't put her hands behind her back. Not the worst resisting arrest you see when you stand where I do. I guess what bothers me the most about this case is that the felony is sealed based on the motion with no objection. Then we come down to the municipal court and we get a different result with the same individual. So it somewhat begs the question, either she's rehabilitated for the purposes of the felony. Why is she not rehabilitated for the purposes of the misdemeanor? And that's where I think the court fails in its discretion. One of the troubling things, and I don't want to go into length, but he noticed that some fines had not been paid. So she runs down the hall, the clerk's office pays them, and then denies the expungement, which nothing illegal about that or wrong about that, but it shows a demeanor of the court. I probably went a little too far in my brief, but it seems cruel to me to do that. When someone has come so far, the legislature has decided that they want a process whereby people can walk away from their older crimes and become productive members of the community without that luggage interfering each step along the way as they continue their rehabilitation. Now, it's kind of a moving target because they keep changing that. Both city and state cite cases that go fairly far back where there's been at least 2 changes to the statute since those cases were decided regarding abuse of discretion, which shows the legislature wants more people to qualify for this benefit. So I would argue that, it becomes happenstance if you can go down the hall in the same building and get a different result. Why don't we have some standards, legitimate standards, that will assist courts in making decisions? And of course, the best way to do that is the state. State argues, look, we've got this interest. This case bothers us. We think it should not be sealed. But that did not happen here. They basically abdicated their position by not arguing. They basically, with the no objection was the only statement either of the council made.
And Attorney Cohen, quick question. You previously referred to the sealing of a felony charge.
Yes.
Is that part of our record?
I don't have a transcript right in front of me. I advised the court at the time that her felony had been sealed.
So it's okay. So it was within the transcript.
It's part of my argument.
Okay. Thank you.
And again, just reiterating that we have a statute which the legislature has given us, where the intent of that statute is to help people move forward. And if you allow someone to seal their record after 1 year, and that individual waits 5 years, I think it meets the purpose of the statute, which is rehabilitation and becoming a part of civil society. And she has absolutely done that based on what her history was. Thank you, Your Honor.
Mr. Cohen, one more question. Under the statute, is it your client's burden to show that she is entitled to have her record sealed?
I think she's entitled to have her record sealed, which is a rebuttable presumption. So the state can argue against it. The court, as it did here, can argue against it.
Thank you.
Thank you. Attorney Lapp?
Yes, Your Honors, may it please the court and counsel, I have several points to make. You first look at whether the court complied with the statutory requirements, and clearly the judge did. The judge held a hearing, asked questions of the participants, considered their answers. The judge had to weigh the factors to make a determination. And the judge, despite whatever changes have occurred in the expungement law, the judge still has discretion. The judge's discretion has not been changed in any subsection of the expungement law. They have opened up how many cases may be expunged, but this is a case, this statute, it still is up to the judge's discretion. In terms of abuse of discretion, the judge was permitted to look at the number and type of convictions, at the timing of them, over what span of time things occurred.
Wait, I'm just trying to understand your argument. Is this regarding whether she was rehabilitated?
Well, that's what I was going to get into. One of the factors then for the judge to look at, because is whether the judge feels the person has been rehabilitated. And the judge's sheets from each municipal court case are in your appellate docket. The transcript docket has the judge's sheets for each one. Those sheets show, in addition to what the crimes were, when they occurred, what the sentences were, that there were often times when she had probation violations and was still having problems with cocaine and with alcohol. There was a capias at least once. All of that could be taken into account by the trial judge.
So how late, so you're saying that we don't just look at the date of the conviction, we need to look at the fact that you're saying that she violated probation after that date? So they're not as old as purported to be because she's still violating?
Well, I'm saying that isn't a part of your record. If you're reviewing whether the court had discretion when it stated did not feel she had been rehabilitated. And so even when a case has ended, more things occurred, and that is a part of the record that you have in front of you.
I was just having a hard time. I read your brief, and that seems to be your argument, but that was not anything that the judge mentioned at the hearing. So he simply said that he didn't believe she had been rehabilitated, and I was having a hard time understanding why.
That's true. He did not go into the details I'm talking about, but that is not required by the statute. The judge considered everything under the statute that must be considered. And the judge stated on the record what his findings were, and he has that discretion. In addition, he considered the defense arguments. There was a statement that the woman wants to get some kind of certification. There was no statement that having misdemeanor convictions would prevent that.
Are you now talking about the E factor, which is separate and apart to rehabilitation, or are you making this argument within the rehabilitation factor?
I have to look up the E section.
So let me clarify.
Yeah.
So the C section is the rehabilitation. The E is the weighing of the interest of the applicant and having the records of the conviction sealed against the legitimate needs, if any, of the government to maintain those records. So you were talking about how the applicant had stated that she had an interest in having it sealed with regard to a licensing. So in your argument, I just want to clarify, are you still arguing within the court's determination of rehabilitation, or are you now talking about the weighing of the personal interest versus the government interest?
Personal interest versus the government interest. But I think all of this plays into each other. Each of these, you're talking about a whole picture when you're looking at this for a judge to make
Well,
this
they're all to be
discretionary
considered.
judgment.
They're definitely, and here's my question on that is, the statute says if any, so the statute recognizes that there are circumstances in which there aren't any. And as counsel has pointed out this morning, the government advanced no interest during the hearing. So it seems to me that there's nothing to weigh against the personal interests.
I think the judge still has the duty to look at what the judge feels the governmental interests are. You know, for years.
So you're saying that the judge acts as an advocate in a sealing
He's not an
procedure?
advocate. In the discretion, the judge has to weigh any governmental interests and the defense.
Well, whose responsibility is it to bring forward the governmental interest?
If the state would like to file an objection, they can, but there's no requirement that they do, and a judge still has to consider the interests. You know, prior to 2018.
So are you
The
saying that
only
the
issue-
objections is the only vehicle to advance a government interest? The government can't articulate an interest during the hearing?
Yes, the government can.
Okay, but in this case, did they articulate any interest during the hearing?
The city stated it did not. The county stated that there were still fees, fines owed, and that had not been paid, which in my mind also go towards rehabilitation. It's been this many years and the fines have not been paid. But it does not, a judge's discretion doesn't end if the state doesn't articulate, we specifically object. That doesn't mean the judge then is required to grant it. The judge still has to weigh the statutory factors.
Attorney Lapp,
Don't.
how, considering, I'm looking at the transcript and the trial court said, I think the government's interest in maintaining these outweigh the applicant's interest in seeking their expungement. And he really didn't go any further than that in talking about what the government interest is. How are we supposed to determine whether there's an abuse of discretion if we don't know on what the judge determined this?
There is no requirement that the judge give X amount of specifics. I think what you look at is what was in the record and the arguments that were made, which the judge did talk about in his statement, however short it was, went over what he felt state interests were versus the defense interests, went over what rehabilitation he felt was or was not accomplished, discussed the number of convictions, the severity of convictions, and that is sufficient in the record to show that he exercised his discretion in making this determination.
Is it appropriate though? I mean, the expungement or sealing laws have been amended so that people can seal multiple convictions. It used to be very limited. And is it appropriate to base lack of rehabilitation finding on the number of convictions when statutorily she qualifies?
If all a judge said was the nature of the conviction, that's insufficient. The judge didn't only say the number of them. You can look at it's in the record and it was stated exactly what the convictions were.
So it's you believe, even though he didn't articulate that the lack of rehabilitation was based on the number of convictions that she was trying to seal?
He didn't say only on the number of convictions.
He didn't say either way, did he?
It was
This is what you're kind of extrapolating from the hearing.
Yeah.
That it was based on the number of convictions, and you're saying that that is an appropriate consideration, even though she statutorily qualifies for sealing?
Yes, that's one of the considerations in all of the facts and circumstances, the cessation and continuation of criminal behavior, education, employment, any other circumstances that may affect rehabilitation. Excuse me. I can get it. All of those are things that could be looked at, and as the judge stated, I'm going to apply the law, whether the prosecutor objects or not. First, the court has to question whether and he went through the factors and stated specifically that the most recent case was resisting arrest. He named possessing drug abuse, he named each of the crimes and stated he did not feel that these as a whole showed rehabilitation.
Was the 2016 resisting arrest, was that a county case or a city case? That's the latest, right?
I know it was in front of the same judge. Give me 1 second. It was a city case.
Okay.
The 2016 was a city case, but that judge did hear that case. And I think the judge.
If you'd like to wrap up your arguments.
Yes. If the judge could look at what the defendant's statements were, the defendant didn't say that anything had been prevented by having these misdemeanor convictions. It didn't say it was preventing housing, education, employment, any of the things that the judge would look at. So I feel,
does the defendant have to say that though? I mean, isn't it kind of a given that having a rap sheet is going to cause you issues?
not
in
in
your
the
life?
case law. I mean, the case law on expungements, there's a lot of discussion whether a person has shown that there's going to be any kind of impairment due to their record. It's not ever just accepted that because you have a conviction, you're going to have problems from it. And the cases go into detail when they're looking at abuse of discretion. All of the cases will discuss what the defendants have said their reason for the expungement is. Why they're requesting it and whether that's comparing that with what the judge has said.
Unless there's any other questions from the panel. All right. Thank you for your arguments this morning, Attorney Lapp. Good morning
Sure.
again, Attorney Vogt. You can begin whenever you're ready.
Thank you, Your Honors. I think I'll sort of narrow mine just a little bit. I think the question of whether a court can sort of sua sponte consider the interests of a person in having their record sealed versus the government interest, that's an interesting question, but ultimately one that the court does not have to answer this morning because the record below is clear. Mr. Cohen asked the trial court, so this is on the court's own volition. The court said correct. It does have a duty to consider the law irrespective of whether a formal objection is filed by the prosecutor's office. And there are a number of things, even if a person is defined as an eligible offender, that can be fatal to their having their record sealed if a trial court makes the determination. And as to the rehabilitation element, the question is, we're asking, what did the trial court base its decision on? The question for this court
So
is—
at the end of the day, you're saying that this case turns on on whether there's an abuse of discretion on the determination of rehabilitation.
Yes, Your Honor, I think that's certainly dispositive. And the question is not what this court based its decision on. It's whether for this court standard review, is whether there's anything to indicate that the trial court acted unreasonably, unconscionably, or arbitrarily if it abused its discretion in making that determination. And Ms. Lapp's gone over the record, I think, quite thoroughly about all the things that were available to the trial court. And I don't think that there's anything that says, the trial court said, I'm not going to listen to you, I'm doing this either way. I think trial court was in the best place to determine whether this person was rehabilitated, was certainly aware of the facts and circumstances surrounding the number of her cases. One point I'd like to—
Isn't the issue though, and that's where I'm getting hung up, and maybe you can help me, but you look at the last conviction, which apparently was the resisting arrest, it was a city case, and whether she's stayed out of trouble since then and what she's done with her life since then. I find it kind of hard to understand how you would, if the statute says she can expunge or seal multiple cases, why we would say, well, you're not rehabilitated because you had multiple cases.
Yeah, that's kind of where I was going, Your Honor. I think to your question to Ms. Lapp about, is it improper for the court to consider the number of cases when the trial court or the General Assembly has plainly expanded the availability of expungement? I think the key for me is that subsection, the cessation or continuation of criminal behavior. If it wasn't improper for the trial court if it were improper, then there would be no need to have that in there where it says a court can consider the cessation or continuation of criminal behavior. And I don't think there's anything in the language of the statute right there that says since the last conviction. I think the court's entitled to consider the totality of the applicant's criminal record as a whole. And certainly, as Ms. Lapp indicated, it appears as though at least some of the judges' sheets contain records of probation violations that were filed that I think would be relevant to that factor.
That's a question I had on the 2016 resisting arrest. Were there additional probation violations that were filed?
Judge, I'm not entirely sure. I was trying to, I'm taking over for another attorney in this case, and I should have reviewed the record more thoroughly. I'm not able to see that on CMS. I was bringing up the website just to see the date. Certainly it's in the transcript of the docket available to the court, and I apologize. I don't have this answer now, but I think irrespective of whether probation violations filed on that specific case or not, I don't think the trial court behaved unreasonably if it did consider the totality of the number of cases for which Ms. Smith was, the applicant was seeking sealing. So unless there are any other questions, I'll submit on the rest of my brief and ask this court to affirm.
Thank you. Thank you for your argument this morning.
Thank you, Your Honors.
Attorney Cohen, I've carried over the remainder, so you have 5 minutes for rebuttal.
I'll try not to use it, Your Honor. Thank you. I guess the difficulty I have here is city and county are trying to extrapolate what the judge was thinking. Well, the only evidence we have is what the judge said, that she was not sufficiently rehabilitated. And that's where his decision is unreasonable, arbitrary, and unconscionable. And
But are you saying it's because he didn't articulate?
well, I'm not really saying because he didn't articulate. I think his decision was an abuse of discretion. The lack of articulation, though, does not give the city or the county permission to fill in those gaps.
Well, I think they're just pointing to the record and saying, there's no requirement that the judge explain his reasoning. But if you look at the record, it wasn't an abuse of discretion to come out the way he did because of what was in the record.
But what was in the record was, one, she was an eligible offender. So the legislature anticipated that these offenses come in. The number, the type, the probation, whatever else is irrelevant because it's not, the statute doesn't talk about that. The statute talks about convictions.
So
We're
you're
talking
saying
about
that does
conviction.
not go towards rehabilitation?
Well, 5 years of sobriety, her own house, her own business, young children, participating in the community. I've had felony cases where clients have done far less than that and get their records sealed on a felony without any objection from the state of Ohio. So what does that, again, tell an individual who has worked extremely hard to clear up their life?
Then let
They
me
go
ask
up
you
onto
this,
the
Mr.
third-
Cohen. I think this would be helpful. Do you have a case that you can cite to us in which there was far less or similar, and it was determined to be an abuse of discretion? It was determined to be an abuse of discretion from the perspective of rehabilitation.
Well, there's a case from many years ago, I'm going to say 25, maybe longer than that, where a minor misdemeanor was not, couldn't get an expungement because of the nature of the felony offense. And they held that getting rid of that minor offense was not appropriate. It was within the court's discretion. But the thing is, we've come a long way since then. And legislature has decided that it wants to give people a break. And if you're talking about rehabilitation, what is the standard for rehabilitation? What the individual does since they committed their last offense.
Mr. Cohen, could you please address Ms. Lapp's contention that your client needed to show more to show her interest in having the conviction sealed? She needed to show why her record was affecting her life and how it was affecting her life.
I don't think the statute requires them to do that.
Well, what
She
about the
did.
case law?
I don't think case law does either. There is an interest in cleaning people's records up. She stated she had a licensing interest, and at any point somebody could have asked, what is that interest? I explained that it was a business interest based on where she was going with her business. And I advised the court as to what her business was. It doesn't, I think it defeats the statutory purpose and certainly legislative intent to let people clear their records and move on. And I know there's no magic number on rehabilitation, but what better evidence can you have than somebody's lack of criminal conduct for 5 years? Home ownership, business ownership, raising a young family. This is a disability that does not need to continue. And the city and the state sat on their rights. And as far as one thing that aggravated me is when the county argues, well, she owed fines. Are we not going to deny people expungement because of poverty? Well, she went down and paid those fines. It's in the record. She gave us a brief continuance. We go down the hall, pay the fines, come back, show the court the receipts, and then not expunge it. So I think if there are no further questions, I'm done here. Thank you, Your Honors.
Okay, thank you all three for your arguments this morning. We will take the matter under submission, issue a timely decision, and we wish you all a wonderful and safe afternoon.
Thank you, Your Honors. Take care.
Thank you. Your
Okay, and that concludes our argument.